This is Werner Sabo. I'm a construction attorney and architect in Chicago. I'm also an arbitrator and mediator. In these videos, I discuss arbitration and mediation topics. I want to talk about how I handle arbitrations, my philosophy of arbitrations. Every arbitrator is going to handle an arbitration slightly differently, although I think there are going to be many common areas that all arbitrators, all good arbitrators, are going to follow. But I do have certain views of how an arbitration is to be conducted. I've done many arbitrations. I've also represented a party in arbitration, so I've seen how other arbitrators arbitrate their cases. This is totally different than mediations. In a mediation, I do not impose any kind of award on the parties. I try to convince the parties to settle a case. As an arbitrator, though, I'm much more like a judge. I hear evidence and I issue an award at the end of this process. So let me explain to you how I view arbitrations. I think there are three important things that I do, how I see the arbitration. Number one, I want to be fair to the parties, the participants in the arbitration, give them a fair and equal opportunity to present their case and have me hear their positions on the various issues. Number two, I'm going to follow the law as it's written. Now, having said that, there are many areas of law that are undecided and are open to interpretation. So there, I'm going to try to do the best that I can and follow the law as I understand it, and to be as fair as possible to the parties. I want to listen to the evidence in the case as the parties present that evidence. Now, I need to tell you that if I'm your arbitrator, I'm not your attorney. You have to have, hopefully in a construction case, you're going to have your own attorney who will be presenting evidence. Now, I'm an arbitrator for the American Arbitration Association, and I've done a number of some of their very small cases. And in some of those cases, one or both parties don't have attorneys. But here I'm going to address the more typical case where there's a substantial amount of money at stake and the parties have wisely chosen to be represented by competent attorneys who are able to pull this evidence together and present it in a reasonable way that I can understand it. Now, I also feel that I have a duty to the parties to move the case along and to do this in a fair and reasonable way. And this is most important prior to the start of the actual hearings, where issues of discovery come up, and there are sometimes several months go by between the time I'm assigned to a case and the hearing actually starts. Often this is because the attorneys are looking at discovery and are doing various things that they feel like they need to do. An important thing to remember is that arbitration is a creature of contract. So there's a contract between these parties that are in front of me that requires them to arbitrate. Usually that contract is entered into at the start of whatever project they're doing, whatever it might be. Occasionally, there is no arbitration agreement in their contract, or maybe it's a handshake deal, and a dispute arises, and the parties then later decide that they want to arbitrate it. That's very rare. So the typical situation that comes in front of me is that parties to a construction project have a dispute, they can't resolve it by themselves through negotiation, and maybe the mediation has not been successful. So now they're in front of me, and I will hear the evidence and decide the case. As an arbitrator for these parties that are in front of me, one of my most important roles is to keep the process moving and to give them an arbitration process that's economical and as quick as it possibly can be. Unlike in court, where you're really at the mercy of the court system, arbitration is a creature of contract. The parties have decided to arbitrate the case. They select the arbitrator, and in this case, hopefully they've selected me as the arbitrator. And they expect that I will move this case along as quickly as is necessary. It's often driven by the attorneys, and they may have certain things that they want to accomplish prior to the hearing. Maybe they need expert depositions, maybe they need to depose parties and so forth. And I'm going to talk about discovery in a couple of minutes. But I need to move this case along to minimize the cost to the clients that are involved. One of the reasons for arbitration is that it's hopefully quicker and more economical for the parties, as well as having somebody decide the case who actually knows something about construction. So my job is to not only be fair and equitable, but it's also to keep this process moving and provide an award to the parties in an expeditious fashion. Now, the hearings are, of course, the primary focus of an arbitration. And when I conduct the hearings, when I'm in charge of hearings, I try to move those along as quickly as possible. I try to give the parties what they're looking for. And usually that's a full day of hearings in a way that the hearings can be conducted consecutively. Now, in court, you might have a day here and a day there, but in arbitration, generally, unless it's a very large case where you have several weeks of hearings that may need to be broken up, in most cases, we can do several days of hearings that are back to back. And so the train of thought is consistent, and everybody can put their evidence on within a reasonable time period. So I want to keep that moving. That also means that we try to keep the witnesses down to a reasonable number. We don't want to have repetitive witnesses. You know, one witness has certain testimony, and then the next witness basically says the same thing. So I'm going to try to get the attorneys to focus their evidence on as few witnesses as are actually necessary to put on their case. Now, again, I'm not the attorney, so the parties' attorneys need to put on their case. I will hear that evidence that they present and base my ultimate award on the evidence that's provided to me. Now let me talk about discovery for a minute. Discovery is the process where the parties are, and generally it's the attorneys, that are pulling their evidence together. And it may consist of the documents that their clients have, and there could be thousands, hundreds of thousands of pages of documents. In construction, there's going to be drawings, specifications, change orders, and tons of correspondence, emails, and so forth. And the attorney's job is to pull together those documents that support their theory of the case. So there may be an issue relating to the roof, and something happened with that roof. That's an important issue in this arbitration. So they're going to pull together the documents, whatever those may be, that pertain to that issue, as well as the various other issues that apply. So to do that, they're going to have to come up with documents from their own clients, perhaps documents from the other side, and perhaps documents from elsewhere, from the municipality and so forth. The attorneys are going to possibly want a document exchange, which is pretty typical among the parties. So generally, each side is going to request documents from the other side, and I try to move that process along to expedite that. Each side in many construction cases is going to have experts, and generally we allow depositions of those experts. The experts probably are going to have reports, and after the reports are in, it's typical that the attorney for the opposing side is going to want to take that expert's deposition. Now, depositions in court, they could go on forever. And that's where court cases get really expensive. If you take 20 or 30 depositions, that's a lot of time and a lot of money. So in arbitration, especially construction arbitrations, I find that most parties have a lot of information already. And so the owner is going to have probably most of the same documents that the architect has, that the contractor has. Obviously, there's exceptions to that, and there are some documents that one party may not have that the other party has. So I will try to help those attorneys work out how to get access to those documents. But depositions is another matter. And generally, attorneys, I've found, want many more depositions than are really necessary to decide that case. That's expensive, and the clients have to pay for it. So when I first start talking to the parties, we have conference calls after I'm first appointed to be the arbitrator. And in those conference calls, toward the beginning, I'll ask, well, how many depositions do you see that you're going to need? And sometimes I'll hear, well, I need 20, I need 30. So I strongly discourage that many depositions because they're generally just not necessary. So I'll ask the attorneys, well, why don't you start with 1 or 2 depositions per side, and then take those depositions and then come back. We'll have another conference call, and we'll try to decide who, if any, additional depositions are going to be needed. And most of the time, I find that after the initial round of 2, 3, 4 depositions are taken, maybe 1 or 2 more are identified that are really necessary. But generally, we stop it at that. Now, other types of discovery include interrogatories. I highly discourage the use of interrogatories because I find that 98% of the time they're a total waste of time. And so unless something is really incredibly important, interrogatories are just not very useful. Motion practice in arbitrations is generally discouraged because they're largely a waste of time. You don't really get anywhere. The exception being some dispositive motions that actually could take care of the case and determine the outcome of that case up front before a lot of time and effort is spent. And by that I mean something like a motion concerning statute of limitations. So the attorneys have looked at this, and it turns out that there's some real solid evidence that the events that are at issue here have occurred way beyond the applicable statute of limitations. And it's clear that this case really shouldn't go anywhere. So a good motion that lays out the facts and why the case should be dismissed, that's a good motion. And I'll certainly look at that, and if that's the case, then the case ends right there. But most of the motions that you see in court typically are not going to go anywhere in an arbitration. Motions for summary judgment generally are not granted. It's very rare to do that. You want to hear the evidence. You want to get a chance to have that rebutted by the other side and so forth. And the hearings themselves are going to determine the outcome of the case. So the standard types of discovery that you see in court, some of it is still there in arbitration, but it's going to be highly abbreviated, and the good attorneys that understand arbitration are going to be attuned to how the discovery process can be moved along as quickly as possible. And I, as the arbitrator, are going to try to keep the costs of the arbitration down and move that to a hearing, because that's where the case, in most instances, is going to be decided. Now, one thing that often pops up in arbitrations involves third-party subpoenas. Arbitrators generally can issue subpoenas, and they can issue them to third parties. So third parties are folks that are not in front of me, that have some relationship to the dispute, but they haven't agreed to arbitrate. They're not affected by the outcome necessarily, but they may have some information that will help one side or the other. So the question is, do I, as the arbitrator, issue a subpoena to a third party? And the answer depends on the circumstances. There are, in my mind, there's two types of third-party subpoenas. One is the friendly subpoena, where you may have another party, let's say it's a subcontractor or a consultant, who has some information. And they're willing to provide that information, but they don't want to be seen as just helping this guy or that guy. And so to sort of protect themselves, they want to have a piece of paper that orders them to turn it over. And they're more than happy to turn it over, but they want that piece of paper. So if you explain to me in a conference call, because this is rarely a secret among the parties, that this is basically a friendly subpoena, I'll go ahead and issue that. That's not a big deal. The concerning part is if it's somebody that really doesn't want anything to do with this arbitration and doesn't want to go through thousands of documents to comply with your subpoena. And so generally, my general reaction is, unless you can show me a really good reason why you need this, I'm probably not going to issue a third-party subpoena where it's evident that there's going to be a problem. Now, I may also have you, if you want to issue that subpoena, and I'm kind of inclined to do it, I may have you put a note on the face of the subpoena that if that third party wants to object to that subpoena, here's how to do it. Maybe they send a letter to the Arbitration Association saying that they object and giving their reasons for objecting. And I may well grant that objection. To me, it doesn't seem fair to have somebody have to spend a ton of money and effort for a situation that really doesn't involve them, where they don't have any skin in the game, and it's just because these other parties have an issue why should this party have to go through all this effort? And you know, the courts are all over the place on that anyway. So, and I also find that a lot of times if you issue a third-party subpoena and they don't want to comply, they're just not going to do it. And, you know, what happens then? More cost, more effort for the attorneys, and cost for the client. So third-party subpoenas are highly problematic and dubious in my view. Let's talk about awards. My philosophy in awards in construction cases is that generally the issues in a construction case are somewhat complicated. It's rarely one single issue that's at stake here that I have to decide. So frequently I find that there's 5 or 10 or more separate little pieces that comprises this dispute. And in the old days, when I first started arbitrating, 30 plus years ago, the practice was you would issue an award that says party A gets $1 million, and that's it, like 2 lines. That's just not a good way to do it. And I didn't like it when I represented a party, and I don't want to do that when I'm the arbitrator. So even though the parties may not decide on a form of award, which is something they actually can decide by agreement, I will generally issue, at the very least, a breakdown of the particular items and what they are and the cost for that item that totals up to the award that I make to one side or the other. So maybe there's claims and counterclaims, and I'll go through that line by line. So at least you know what it is you're getting and how I came up with the award and then the number, the rationale behind it. And it may be a couple of pages. It may be much more than that. The parties, by agreement, can ask me to do as thorough and complicated an award as they want, knowing, of course, that the more time I take on it, this is going to be by the hour, and their clients are going to wind up paying for that. But in some cases, especially in a larger case where a lot of money's at stake, they may want that, and I'm happy to do that. But I think in most cases, for an average construction case, a good breakdown of the award is what the parties really are looking for. And I know when I represent a party, I know that's what I'm looking for. I want my client to know how that arbitrator got to the number that she got to. Arbitration is a creature of contract. So the contract will govern how the arbitration is to be conducted and how I, as the arbitrator, are going to proceed on this arbitration. So maybe the contract says that there has to be a hearing within 60 days of the appointment of the arbitrator, and there has to be an award within so many days of the close of hearings. Maybe the contract says that the arbitrator has to follow the rules of evidence of whatever state that you're hearing this case in, and so forth. So there's all kinds of possibilities. Now, generally, I will have an initial conference call with the parties, and I'll review what their agreement says. And so, for instance, if it says you have to follow the rules of evidence, I will have a long and hard discussion with the attorneys about that, because I think first of all, it's a terrible idea. It's going to make the whole arbitration incredibly expensive, and it just, you might as well be in court if you're going to follow the rules of evidence. So I strongly discourage that. And generally the attorneys who are familiar with arbitration will certainly agree with that. And we'll get together on how this arbitration really should be handled. So again, during the entire process, the parties can change the agreement as long as the parties agree on whatever rules there are, whether it's deadlines or how many arbitrators or whatever else it is, the parties can always agree on certain things. And I will go along with virtually all of those, with a couple of obvious exceptions that I may not agree to. So if the parties want something that I think is absolutely totally wrong, my ultimate sort of recourse is to resign from that case. But that's never happened to me yet. So the parties and the attorneys for the parties and the arbitrator need to work together to streamline this process and make it as efficient as possible. And I will try to do that with the attorneys, and mostly it works out pretty well, with the possible exception of having too many depositions and stuff like that. But it generally works out in the end. So to summarize this, the philosophy that I have is to provide a fair, efficient, and reasonable award as quickly as possible, given all the circumstances of that particular case. And I try to tailor the process and the hearing to the needs of the parties. And if I see that something is going off the rails, I'll talk to the attorneys. This is never ex parte. This is always in conference calls with the attorneys. And I'll try to get the case back on track. And generally that works. I try to provide an award that the parties and their clients will understand how I got there, so it's not a big mystery. I try to make that award as bulletproof as possible. The attorneys are going to know what that means. Arbitration awards are extremely difficult to overturn, but there are some grounds for overturning arbitration awards. And I try to have an award that is clear and concise and backed by the evidence that has been presented to me. And if I do that, it's very difficult, virtually impossible, to overturn that award because I've made some kind of dumb error in it, or I haven't explained myself properly. That serves the parties, because the last thing that you want is to have the loser go into court and challenge the award and then maybe go up on appeal and so forth. And if there's something murky in the award, you're asking for trouble. So I really try to avoid that possibility. I'm careful with how I word that award and make it as clear as possible so that a judge looking at it is going to understand exactly how I got there. And I think that serves the interests of the parties.